My name is Craig Gordon. I'm one of the vice presidents and shareholders here at Prevail. And I'm excited for you all to hear what we believe is a very impactful and important topic. I think sometimes estate planning can, in many cases, feel daunting. I think it can be confusing, sometimes maybe complicated. And as a result, what do we naturally do? We sometimes procrastinate on those typical items. The other thing is that we are always evolving. Life is always changing. And so what might have been applicable prior to planning may not be applicable now. At Prevail, we do a lot of these events. Some of you, I've seen some familiar faces. Most of these events are on wealth building strategies, right? How do we create wealth, investments, private real estate, venture capital? We do some really cool things here, and I'm proud of that. But what I can tell you is that all of those things are left incredibly vulnerable if we don't have the right planning in place. So I'm excited for you to hear some of this information today. And there's no two better people to provide that information than who we have here. We have Daniel and Connor, joined by Margaret as well. Margaret is a law school student, going to be graduating pretty soon, does a lot of behind the scenes work. We got a great team here. But Daniel used to work worked in the White House. He under the Bush administration. He has also defended and litigated, or I guess kind of defended against litigation on estate plans, which I don't know if you know that's really important, because when we draft these documents, everything goes great until it doesn't. You want somebody that understands what potential blind spots could be in there. But most importantly, I think Daniel, and I've worked alongside Daniel now for a while, I love how he simplifies what otherwise is a pretty complicated process and makes it easy to understand. That's really, really important. Connor, incredibly educated here. He got a master's in taxation. If you know us about Prevail, we pay a lot of attention on tax mitigation strategies. This becomes very, very important, because what are we doing from an estate tax perspective? We want to, in many cases, insulate dollars from taxation. Also, for business owners that are in the room or watching here, really important, because both of them, in particular Connor here, knows how to navigate the business aspect with the estate planning aspect. Advanced planning, advanced trust work, charitable trust work, special needs trust work really falls in to Connor's camp. So again, we've got an incredible team here that can implement, educate, and execute on various estate planning topics. So with that, I'm going to turn it over to Daniel.
Thank you, Craig. Good afternoon. My name is Daniel Schowengerdt. I'm the general counsel of Prevail Wealth Management and also own Schowengerdt Law. I started my career for the first 18 years litigating trust disputes, will disputes, and business law disputes in court. And unfortunately, that's usually between family members. Now, my practice is dedicated to estate planning and business planning to keep families out of court. So today we're going to go over, for me, you're going to have me for about 15 minutes, and you're going to have Connor for about 15 minutes. I'm going to go over foundational estate planning. So foundational estate planning, three main topics, and these break out a little bit. First, we're going to talk about guardian designations for minor children and what it looks like if a parent were to pass away without that, and then what it looks like if they pass away with it. We're also going to talk about incapacity planning, a very important but sometimes overlooked part of estate planning. And that's having power of attorneys if you became incapacitated and you weren't able to take care of your health care or your financial needs. And then last, we're going to go over revocable living trusts and wills. I'm going to break down the difference between them and the pros and cons of each one. So when we say estate planning, what are we talking about? This is the foundation right here, all these documents. So if you don't have all of these documents, this is where you start. I want you to notice one thing, that there's only one line dedicated to revocable living trusts and wills. It's an incredibly important part of the process, but that's really for your kids or your beneficiaries. When you create a trust or a will, that's for their benefit. You're not going to be here. It's really not for your benefit on a normal trust. But the incapacity planning, that's for you. So we're going to walk through all of them here. But first is the why. Why do an estate plan? And if you have minor children or grandchildren, that's your first why. Now, in Kansas and Missouri, the only way to designate who you want to take care of your kids when you're no longer here is through an estate plan. I have up here that if you don't do it, custody disputes can happen. So you may wonder, how could that be? Mom and dad are passed away. How's there a dispute over custody? I'll give it with an example. I had a real case several years ago. where a mother and father were driving down the road on a family vacation, and they had their 10-year-old Mack in the back seat. And tragically, got in a car accident, and the parents died. Mack was in the back middle seat, so he survived, but he spent the next 16 months of his life in a bitter custody battle between his aunt and uncle trying to raise him. And the reason that happened is because the dad had those two siblings. And over time, he had told his brother at one point, something happens to us, I want you to raise Mack. And at another time, he told his sister, if something happens, I want you to raise him. And this is very common. The aunt and uncle, they had problems before this started, but he allowed a vehicle for them to argue because both of them got to say, this is what they wanted. I'm honoring my brother's wishes, and I'm trying to do what's in Mack's best interest. Now, they each spent over $100,000 fighting the case. It lasted 16 years. I represented the aunt. She ultimately won. She won custody, so Mack's in her care right now. But really, everyone lost because the aunt and uncle, they'll never speak again. Mack won't be allowed to see his uncle until it's his choice at 18. And unfortunately, we had to have Mack testify. And I wasn't being insensitive by putting Mack on the stand. I had to, because one of the statutory factors for Kansas for custody is who do you want to live with? So Mack had to get on the stand and say which aunt or uncle he wanted to live with. And the biggest part of this is it was avoidable, very easily avoidable with an estate plan. So what's that process called? That process is called probate. Probate is a process that if you pass away without a proper estate plan, then it goes to court to decide who's going to raise your children and where the money's going to go. The easy way to remember it is probate is the devil. Probate devil. No one plans on probate. Probate happens with a lack of planning. And if someone's ever been through one probate, they're usually never going to go through a second one because they're going to make sure their kids, their parents, whoever has an estate plan in place. The reason for that is because probate lasts an average of 6 to 18 months, and it costs 2 to 4% of the estate. So let's say your estate's worth $1 million. If you liquidate your house, all your financial accounts, your vehicles, and that equals $1 million, that's going to be about $20,000 to $40,000 on a simple probate. I mentioned in Mack's case, each one spent over $100,000 because there were problems. Now, on the flip side, most attorneys that are going to do an estate plan for you, for a couple, it's going to be about $3,200 to $3,800. So 10 times less on $1 million. How do you avoid it then? 2 main paths to avoid probate. The first is setting up a irrevocable living trust, and it has to be properly funded. Now, by funded, what I mean is attorneys are really good about creating estate plans and creating trusts, but historically, they're very bad about instructing their clients how to put things into the trust. So most trusts in the United States of America don't have anything in them. There's no house or financial accounts. So when creating a trust, it's very important to make sure the house and all financial and title property is in that trust. That avoids probate. The second way is this generally is applicable if you only have one child, is doing transfer on death and payable on death designations on all title property and all financial accounts. So everything's automatic. As soon as you pass away, your house, all your property immediately goes to whoever you've designated. Let's go over trusts. A few of the benefits of trust. First, it avoids probate. So it avoids that devil. They're not going to have to wait 6 to 18 months to get any funds. It's going to be right away, or at least as soon as the trustee can settle the accounts. It's also flexible. What I mean by flexible is, so trusts are governed by contract law. In the United States of America, we have freedom to contract. So I can contract with you with anything I want to as long as it's legal. So in a trust, it's the same. You can put anything in it you want. That's not real helpful to tell you. It's easier if I give you some examples. So there's sort of a pendulum on what you can put in. Now, Mack is going to get everything at 18 years old. There's nothing I could have done, nothing the judge could have done to change that, because that's what the law is. If you don't have an estate plan, you don't designate it, they're going to get it at 18. But you could also choose for your child to get it at 18. In 17, 18 years of doing this, I've never had anyone actually do that. And we'll talk about why in a minute. But on the total opposite end of the spectrum, Connor and I had a client who's really an ultra high net worth individual last year. he instituted what's called the no slug rule in his trust. So his kids are only going to get, when he passes away, equal to whatever they make a year. So if they make $20,000 a year, they get $20,000 a year out of the trust. If they make $1 million a year, they get $1 million a year. That's it. They get nothing else, and it's going to go on for generations. You may think that sounds crazy. I don't agree with it. All that mattered is that's what he wanted, and it's his money. And then you sort of have a sweet spot. So in the middle, I call it the gold standard. It's what I have. I have an 18-year-old son and a 16-year-old daughter. So in my trust, I have that my kids will get no money until age 30. My sister's appointed as guardian and also as trustee. So from the time my wife and I pass, they will be able to be provided for HEMS. That's health, education, maintenance, and support. So my sister will be able to pay for their health care, pay for their education, and then their maintenance and support, things that they need. And then they're going to receive a third of the money at age 30, a third at 35, and a third at 40. The reason I've done that is because I want them to go to college or trade school or start a business. I don't want them to be a trust fund baby. So this takes care of their needs, but also protects them from themselves. So what's the worst that can happen? I have a picture up on this next one, and I want you guys to literally just out loud guess what it's going to be after I give you a little hint. What do you think the first thing an 18-year-old is going to buy if they get an influx of cash? Let's say $300,000. What color do you think it is? Red. Red car. That's what they are buying. I represented hundreds of these 18-year-olds, and I implore them, don't do it. They think they're making an incredible financial decision by putting $150,000 away, maybe investing, maybe a bank account, and the other $150,000 on a Ferrari. They think that's great. So let's do the math. We have a lot of financial advisors here. They'll check me if I'm wrong. Craig will tell me if I'm wrong here. Let's say instead you said I'm taking control of that, and you're not going to spend that money because you set up a trust. And from age 18 to age 60, if that $150,000 were invested and gained 7% interest because of compound interest, it'd be $2.5 million. If it's 10%, it's $8.5 million. So 18-year-old can either have this red car for about 5 years or $2.5 to $8.5 million for their retirement. Now, I have an 18-year-old. I know what he would buy. I talked to him about this since he was a little kid. He still would buy the car. So I'm going to protect him from it. What are other benefits? So other benefits is it's private. You can look up right now in Allen County, Kansas, and see Mack's case. You can see the transcript of how I questioned him. You can see the exact amount of money he's getting from his parents because it's all public. Wow. In a trust, that's private. It can also protect your family's inheritance from divorce and creditors. So creditors first. Let's say my sister is going to be trustee and guardian of my kids. My kids are, say, 28 years old, and she gets sued. She gets in a car accident. Her money can be taken. The money in trust for my kids is completely protected under what's called a spendthrift provision. And any attorney worth their salt is going to make sure a spendthrift provision is in there. How about divorce? So I did divorce law for 15 years, and I don't think I ever heard someone say in a divorce, I really wish my ex-son-in-law or my ex-daughter-in-law would get half my stuff. They don't want that. But in a divorce, anything that's pooled is going to be split equally. If it's in a trust and it hasn't been distributed, so if my kids are 28 years old, they get divorced, that money is unavailable to be split in the divorce. There's another thing that's optional you can put in a trust. I have in mind that I'm requiring my kids to, if they're going to benefit from the trust, they have to get a simple prenuptial agreement that just says in the event of a divorce, the spouse that's not in their lineage, they don't inherit. I've done several hundred of these agreements, and I've never had anyone argue over it because it just makes sense. They're going to say, yes, I probably shouldn't get that. In the heat of a divorce, different story. So that's one thing you can include as well. Now, for any business owners, there's also incapacity protection. Whenever you create a trust, you should do either a transfer on death or, better yet, put the business into the trust. It doesn't change your ownership. It doesn't change anything else other than its title in the trust. What that does is if you become incapacitated, you can't take care of your healthcare needs or your medical needs or your financial needs, your trustee can come in and they can run your business. and it can help prevent a liquidation event. And then, of course, charitable giving. You can give to your local church or your favorite charity through it as well. And there are some ways to get some tax benefits from that as well. Okay, how about a will? So a will, it's not always the worst option. And the reason for that is because you can do some similar things in a will. You can name beneficiaries, you can name guardians for your kids, and you can even set up what I talked about, giving them money at certain stages. The worst thing about a will, though, and something to keep in mind, is it always goes to probate. You only have a will. It's the number one misconception in estate planning. People think if I have a will, I'm good. You're not avoiding that devil with a will. It's going to go to probate. That's 6 to 18 month process. Costs 2 to 4% of the estate. So easy way to remember it is a will is a little bit easier for you now. And the reason for that is because you don't have to retitle assets. We talked about titling assets into the trust. With a will, you don't have to do that. So it's a little easier for you now, a lot harder for your family later. And then with the trust is a little bit more work now because you're putting things in that trust. A lot easier for your family later. Okay, so that's the first part. Remember, estate planning isn't just about wills and trusts, though. Incapacity protection is arguably more important. Because like I said, the trust, that's for your kids. The incapacity planning, that's for you. So I'm going to use Craig's dad as an example. So Craig Gordon, vice president who introduced me. This is hypothetical. Everything else is true. Let's say he called me and said, can you do a power of attorney for my dad? I'm going to ask him the same thing any attorney would. Okay, tell me what's going on. And if he says he's got some dementia, he's not in his right mind, and he can't take care of his healthcare or his financial needs, I'm going to tell Craig, I'm sorry, it's too late. If he doesn't have the capacity to take care of his healthcare or his financial, he doesn't have the capacity to sign a power of attorney. I've had to have that conversation with lots and lots of people. What happens is we have to go through something called a guardian and conservatorship. So Craig would have to hire me as his attorney. We'd have to have a separate attorney represent his dad. And then his doctor would have to come into an open public court and testify that his dad can't take care of those needs. It's an embarrassing process generally, and it's expensive, usually about $5,000 to $10,000, depending on the complexity. And it's very avoidable. It's avoidable that before incapacity, making sure those power of attorneys are set into place. So what are all these incapacity documents? First, financial power of attorney. So that's what Craig can do for his dad. He makes sure he can pay his bills. He's incapacitated. But there's a practical aspect as well. A few months ago, my wife and I had fraud on our account, so I needed to order a new debit card. I went in and I was trying to order one for me and her, and the bank that I represent said, no, she has to come in. I was like, it's a joint account. Can you just do it? They said, no, you can't. I was like, wait, I've got a power of attorney on file. So they took 10 seconds, saw it. They said, oh, nope, you're good. So they were able to get it. When we bought our house, I was out of town, so my wife was able to sign for it. I've been trying to tell her for many years, this isn't legal advice for this part. If I give you permission to use my signature, you can. She doesn't believe me yet until we had the power of attorney. Healthcare power of attorney. So that would allow Craig to be able to make healthcare decisions for his dad, consent to surgeries. But there's also a practical aspect of that before incapacity also. Like I said, I have an 18-year-old son. He's a senior in high school. Pray for me. It's not fun to have a senior in high school that likes to say, I'm 18. But he is, which means I have no right to his medical information. I have no right to his access to be able to see anything. So a month ago, he decided, even though he's getting ready to have a track scholarship to these D1 schools next year, that he broke his wrist playing basketball. And he drove himself to the doctor's office, which I thought was kind of cool for him to do. I would have preferred he called me. But he gets there and the doctor called me. And he said, hey, your son's here. I'm so glad I saw you had a healthcare power of attorney on file, because otherwise I wouldn't have been able to talk to you. I wouldn't have even been able to call you. So it's important to be able to have for your adult children these power of attorneys if that's something that you want in a situation like that. The next is HIPAA authorization. This is a relatively new document. What it is you can appoint as many people as you want to be able to get your health information. Now, I'll have to explain what that looks like. I have 9 brothers and sisters, and I have all of them on there because if I'm in the hospital after an accident, I don't want everyone calling my wife to see what's going on. I want them to be able to get it. Now, they can't make decisions because I haven't authorized them to, but they can at least call into the hospital and see how I'm doing. Now, the last, living will or advance directive. Whenever you go to the hospital, I notice that they'll ask you, do you have a living will or advance directive? I never explain what that is. Now, what that is it's a document that you're saying what your end of life care will be like. And none of us are promised tomorrow. So that could be tomorrow, that could be when you're 100 years old. Well, like for example, mine, it's a Kansas statutory form. And it says that if two doctors, one being my attending physician, say that I am brain dead, I'm in a vegetative state, to pull the plug, if there's no chance I'm coming back. The reason I have that is because it's me showing my wife what I don't want that decision on her. I don't want her to have to live with that she pulled the plug. And my parents, who are here in the other room, your parents, no matter 44, no matter how old you are, it's great to have your parents support you. They're here. I don't want to have to make that decision for them, or else I'm going to have 9 brothers and sisters telling me I didn't have enough faith, or why'd you pull the plug on mom? But that's their decision. And so it's really a gift to be able to give and take the burden off of them. All right, before Connor comes up, kind of my final thoughts, and I'll come up for some questions, but avoid the devil, avoid probate at all cost. And I hope what you've seen today is that estate planning isn't just wills and trusts. It's about incapacity planning as well. So remember, that's for you. Now, Connor Works is going to come up. Connor and I met a while back. We were in a 3-day conference for advanced estate planning. It was nationwide. And I noticed there was this one person at the end of day one that knew better and knew more than every single professor that was in there. And so I reached out to him. I was like, I've got to work with this guy. And so now I'm blessed that I get to work with Connor every single day. He decided that 3 years of law school wasn't enough. And so he went back for a whole nother year to get his master's in taxation called the LLM, which helps him perfectly for the topics in his test.
Perfect. Thank you. Thank you for all the information today. That was fantastic. Dale did a great job talking about that foundational estate planning. That's what we've just gone over. We've got the foundation. And so now we want to talk about, once we do that with all of our clients, they come in, the first thing we say is, let's get the foundation in place. And then we can move on and talk about some of the more complex topics. So we'll kind of touch kind of high level on a lot of these topics today. The first is going to be estate and gift taxes, what that looks like, how that works. It's a little bit of a complicated mechanism, so we'll break that down. The next thing we'll talk about is irrevocable trust planning. So we've gone through the revocable trust. We see the good reasons for that. We'll talk about irrevocable trusts. And what we'll do 3 kind of common irrevocable trusts that we see a lot. The first is a life insurance trust, an irrevocable life insurance trust. The second is a spousal lifetime access trust. And then the third is going to be an intentionally defective grantor trust. And I know that's wild to think about intentionally making something defective. So we'll go through that. And then the third thing we'll talk about is charitable planning and how we do some charitable planning. So the estate and gift tax. Back in the early 20th century, Congress said, people are dying and they got a lot of money. And so we want to get a hold of some of that money. So they set up a limit. They said, anything over this amount of money, we're going to take a percentage of. Well, people said, and that's death. So they die with a certain amount of money. They take a percentage above that amount. Well, people said, okay, I'm just going to give away all my money while I'm still alive. And then I won't have to worry about the death tax, right? And so Congress got smarter and they said, okay, we'll combine the estate and gift tax together. So you can give away or die with a certain amount of money. And then everything above that, we're going to take a percentage. So right now, that number is $15 million per person. Everything over $15 million, they're taking 40% of. A huge percentage, 40% of it. Now, Congress also recognized that you give Christmas gifts, you buy your son a car, all those different things. And so they let us give away $19,000 per person per year without ever having to actually worry about that $15 million number. It doesn't cut into that $15 million that you can give away if it's less than $19,000 per person per year. Married couples, wonderful, they get to combine that number. So we get $30 million for a married couple. And when one spouse passes away, we can file a form with the IRS and their $15 million gets ported over to the surviving spouse. So we always get to keep that $30 million number or whatever's left of the first spouse's amount when they pass away. So this is my example. This is Joe. He's a single guy. Makes the math easier. He's gifted nothing during his lifetime, so he doesn't have to worry about any gifting. He's got an estate of $20 million. He did really well for himself. He maybe is a business owner. Maybe he bought some real estate and appreciated. He did a great job. So that first 15 million, no tax. He's good to go. But that last 5 is where the IRS is going to take 40%. He's got a $2 million tax bill, $2 million that his family has to pay. It's due 9 months from his date of death. So if this $20 million, if it's a business, if it's real estate, if it's something not liquid, nobody's got $20 million in cash sitting in a checking account, I hope. They're going to have to find a way to sell the business, or they're going to have to find a way to sell real estate. They're going to have to find a way to liquidate those assets so that they can pay that $2 million tax bill in 9 months. So this is kind of the history of the exemption amount. So we talked about that $15 million number. That's where we were. That's where we are now. You can see back in 2000, it was less than $1 million. And it's gone up a little bit. It went up a little over $1 million in 2005. And then the estate tax exemption just completely went away in 2010. And there were some the IRS gave you the choice. You can pay the estate tax or get some capital gains step-up basis benefit. It was a tax decision. And then in 2015, we had another tax bill. We had 2017 Tax Cuts and Jobs Act, and it went up again. And we've had the one big beautiful bill here this last year that put us up at $15 million. The reason why I want you to see this is because we've had a tax law change, a tax law change, a tax law change, a tax law change. The tax law changed all these different times that the exemption changed. Right here in between 2020 and 2026, we thought this was going to go from about 12 million down to 6. And all these people were planning for that big plummet in the exemption. It all depends upon the administration and the Congress that you have. If we had a different administration or a different Congress, we wouldn't have one big, beautiful bill. And so we'd have a much lower exemption. Who knows what will happen in 2028? Who knows midterms are this year? Who knows what will happen there? The tax law changes is the point of this slide. And so when we plan for the estate tax exemption, we plan based upon what we have right now. We also plan knowing that this number may drop to 0 at some point. And we have to always be prepared to make sure that our assets are protected from the tax and that we're planning while the exemption is still high. What do we do when we plan? Well, here's 3 of the most common things we use. The first one is that irrevocable life insurance trust. An ILIT is what we call it. The great thing about the ILIT is we buy a life insurance policy inside of a trust, or we transfer into a trust. Now that policy's death benefit is not included against our $15 million number. So we can have a nice life insurance policy. We can have a $100 million life insurance policy, whatever it is. If we purchased it or transferred into that trust, it's going to be excluded from our estate. It's not going to cut against our $15 million number. The great thing about the life insurance trust is you got to pay a premium on that life insurance. And so every year, not only did you remove the life insurance from your estate, but you get to pay a little bit into that trust so that we're removing more money from your estate. And so it continues to trickle down the value of your estate over time. The second would be a spousal lifetime access trust. A SLAT is generally what we call them. SLATs are great because they maintain some amount of access for us. So I create a SLAT. I'm the trust creator, the grantor, for the benefit of my wife. Well, I put an income producing asset into that SLAT, and it produces income, and it gives it to my wife. Now, she'll probably go spend it on my kids, but then hopefully she would spend it on us, right? She'd pay our bills, she'd do all those things. The other thing that we could do is I can build a SLAT, my wife can build a SLAT, and now we both are beneficiaries of different trusts. We both have access to the income, but none of those assets are included in our estate. We've removed them from the estate. So any growth on that asset is not going to be included in that $15 million number. The risk with SLATs is what we call the reciprocal trust doctrine. I kid you not, this is 100% published. You can go and read about it after this. I have seen lawyers who have taken 2 SLATs with identical terms, stuck them in front of people, they signed them on the same day, and the IRS will look at that and say, those are garbage, because they're in the same economic position as they were after signing as they were before signing. And so the IRS says this was a fraud, this is fake, we're going to throw them away. So these trusts, all these irrevocable trusts, but the SLATs particularly, it's important that you find attorneys or people who can educate or are educated on them, because You can spend all this money putting these in place, but these issues, these risks, they're simple. And people, if they don't know about them, they fall into these traps, and then you end up wasting the money and fighting the IRS over it at the end. The third one is what we call an intentionally defective grantor trust. Now, like I said, it's weird to think of something as intentionally defective, but the purpose of that is we call it intentionally defective only for income tax purposes. So when the IRS looks at this IDGIT, is what we call it, it'll look at the trust and it'll say, inside that trust is income producing assets. Who's going to pay the income tax on that asset? Well, in the IDGIT, the person who created the trust, the grantor, pays the tax. This is just like our premium gifts in the ILIT. If I'm paying the income tax, I get to continually reduce my estate, and the asset inside the trust continues to grow in value, not having to pay the income tax. So it's another way that we can grow that asset inside the trust, outside of our estate. A lot of times with these IDGITs, we'll sell a business to them, and the benefit of that is we get a discount. It's a great thing. I can take a $5 million, let's do it this way, a $10 million asset, $10 million business. I can sell it to this trust, and I can get a 30% discount on it. So my $10 million business is now worth $7 million in the eyes of the IRS. That's a $3 million worth of exemption we got to keep, that $15 million number. It's $3 million that we get to pass tax-free without ever having to worry about it. If we leave it as an asset included in our estate, we may not get that discount. The IRS may make us sell it, and then we don't have the ability to discount on that asset. So these are three common ones that we see a lot. And a lot of times when people come in and we've got these estate tax problems, they also are really charitably minded. And so we do a lot of charitable planning too. There's kind of two areas that I want to talk about. The first is charitable trusts. There's really two categories of charitable trusts. The first is what we call charitable remainder trusts. This pays an amount every year to the trust creator, and then the remainder, after a period of time, transfers to a charity. So you get a nice income tax deduction for being charitable. You get the benefit of some money coming to you every year. And then at the end, the charity gets to have their asset. They get to receive a donation. Kind of the vice versa of that is what we call a charitable lead trust. The person creates the trust, it produces income, and the charity receives the income. They're the leader in it. They receive the lead income throughout a period of time. And then at the end, the asset gets to be passed along to some beneficiary, maybe your kids, grandkids, whatever it is. So the asset, your family gets to keep it. The charity gets some income over a number of years, and you get to not have to have that included in your estate. The next thing that we have is what are called donor advised funds, or DAFs. Right? The great thing about a DAF is that you get income tax deductions, but you as the donor are advising where the funds go, right? It's exactly in the name. So I put $1 million in a DAF. I can advise it to give money to my high school every year. Let's give $100,000. Well, the high school calls and they say, we're changing the mascot, whatever it is. They decide that they're going to do something that you don't like. You can stop donating to that cause and advise the fund to donate to something else. And so it's a nice way to get a large income tax deduction all at once, while still advising the fund as to what charity the money goes to in the end. A lot of times we'll partner these together. We'll open up a charitable lead trust. It'll donate to the DAF over time, and you get the tax deductions, but you also get to advise. You can change what charity the money goes to over time. We've talked about a lot of different things. I've kind of just thrown it all up here. So we talked about ILITs, the life insurance trusts. We talked about DAFs, the donor advised funds. We've talked about intentionally defective grantor trusts, spousal lifetime access trusts. But there's a lot of words up here we didn't talk about, right? We didn't talk about buy-sell agreements for those of you who are business owners. That's a huge part of our estate planning because a lot of buy-sell agreements, maybe they're done on paper, but they're not funded with anything. So they don't actually work. We didn't talk about special needs trusts, right? Folks that have children that or a beneficiary that is on government assistance. That's a type of irrevocable trust planning. So the point of this slide is to show you there's a ton. There's way more than we could talk about today. We picked three of the things that we think are most common is people don't really understand how the Estate and gift tax exemption works. We talked about irrevocable trusts, 3 of the most common that we see. And then we talked about charitable giving, because that's something that a lot of our business folks are charitably minded, and we wanted to talk about that. But before Daniel talked about that foundational planning, that revocable trust, the pour-over wills, those powers of attorney, HIPAA authorizations, and living wills, so that you can know these are the things that everybody should be getting. They should be talking to an estate planning attorney about those foundational items. And then you should be thinking ahead and saying to yourself, these are the things that I might need in the event that I'm having some of these taxable questions, or even some of the charitable work we can do with folks that aren't having any question about the estate tax exemption. But overall, we want you to know that estate planning is more than planning for death, right? The death planning is for the benefit of your kids. We've got the incapacity planning, that's for the benefit of you. We've got the tax planning, that's for the benefit of you. It doesn't have to be just a smooth transition for the kids. It can be a smooth transition for you while you're alive as well.